Amendments to the Constitution. Here is the wording of Article 5, the amendment article of the Constitution. Follow it in your own copy. The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or on the application of the legislature of 2/3 of the several states, shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes, as part of this Constitution when ratified by the legislatures of 3/4 of the several states, or by conventions in 3/4 thereof, as the one or the other mode of ratification may be proposed by the Congress, provided that no amendment which may be made prior to the year 1808 shall be in any manner affect the first and fourth clauses of the ninth section of the first article, and that no state without its consent shall be deprived of its equal suffrage in the Senate. Now let's adjust the structure so we can see it more clearly. The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution. That's one way. Or, on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes as part of this Constitution when ratified by the legislatures of 3/4 of the several states. That's a second way. Both of these require the Congress to take action. Or by conventions in 3/4 thereof, as the one or the other mode of ratification may be proposed by the Congress. That's a third way and does not require action from the Congress. The words "as the one or the other mode of ratification may be proposed by the Congress" simply refers to the ratification process of the previous two modes of amending the Constitution. As a point of interest, there was no federal government at the time, and the delegates wanted to give the states power to amend the Constitution outside of the federal government control. This is the way they did it. If that was not their intention, why is this third part even mentioned or included? Then there are two prohibitions listed. The first has to do with slavery, and the second has to do with the state's power in the Senate. Continuing, provided that no amendment which shall be made prior to the year 1808 shall in any manner affect the first and fourth clauses in the ninth section of the first article. The reason 1808 was selected is because the delegates agreed that by that time the South would be able to eliminate slavery completely. That was the goal agreed to in their deliberations. Continuing, and that no state without its consent shall be deprived of its equal suffrage in the Senate. This is the other of the two prohibitions for amendments. Amendments cannot take away the state's suffrage in the Senate. In other words, the state cannot lose its control of the Senate. The 17th Amendment destroys the state's suffrage in the Senate, and therefore it is null and void per Article 5 of the Constitution, and should never even have been proposed in the first place. It is surprising that the citizens of the United States and the states themselves didn't pay any attention, and the states lost their representation in the federal government. Returning to the third method of amending the Constitution, it is never discussed. It is a method that is completely under the control of the states. This is not one convention, rather it is 50 conventions, one in each state. Through this process, the states could repeal the 17th Amendment. There would have to be significant correspondence between the states, as any amendment under this provision must be exactly the same in each state. Another item that would help the amendment process that was not included in Article 5 is a time frame, a 7-year period from the first state to the 38th state, with a provision to rescind an approval or add an approval during the 7-year period. Now let's find out exactly what an amendment is. Here is the portion of the definition from Black's Law Dictionary, 4th edition. I have removed the legal jargon and references to make it easier to read. A change, ordinarily for the better, an amelioration of a thing without involving the idea of any change in the substance or essence, any writing made or proposed as an improvement of some principal writing. It is the correction of some error or mistake. There are two types of amendments for those contracts and for those legislations and court proceedings. The portion of the definitions that I have quoted pertain to contracts. In short, this definition clearly states that amendment to a contract cannot change the original document. It can add or explain provisions and can correct errors, but it never changes the original document. A review of the 27 amendments to the Constitution reveals the following: 1 through 11, 13, 15, 18, 19, 20, 21, 22, 25, 26, and 27 add to the Constitution. Amendments 12, 14, 16, 17, 23, and 24 change the basic document and are therefore null and void, as they are improper amendments according to the Law Dictionary. It is interesting that those 6 amendments that change the wording of the Constitution are the ones that have systematically removed the liberties of the citizens of the United States. It is a pity that our educational establishments never teach the concepts of the Constitution. Perhaps that is by design.